So this week we start our final chapter of the semester. This is chapter 5, which the book calls Residual State Powers and Their Limits. This week we cover one particular doctrine known as the Dormant Commerce Clause, and we'll spend our 3 days this week covering that topic. It can be, there's plenty of material that will fill up 3 days and then some. And then next week we'll end with a couple of miscellaneous topics, namely the idea of preemption of state law by federal law and the Privileges and Immunities Clause. So the Dormant Commerce Clause is an, I think, very interesting topic, and I'm going to start out with some background principles before we get to the cases, trying to set the stage for you as to what this concept of the Dormant Commerce Clause is. I've also posted a handout on the Twin page under the course materials folder that tries to give you a good summary of the basic principles of the Dormant Commerce Clause. You might even want to stop and look at that before continuing on with this presentation. So, the Dormant Commerce Clause is considered to be an aspect of what we might call horizontal federalism. So I want to try to explain on this slide what horizontal federalism is, why it exists, why this concept exists, why it's a valuable concept, and when it might be violated. So we've already looked at vertical federalism, or what we might think of as traditional federalism. This is represented by this hierarchical nature of the national government over and above the state governments. Right? So this diagram here on the right side would be an example of vertical federalism. Why is it hierarchical? Well, we know that Congress is given specific powers in the Constitution. We've looked at the Commerce Clause, but we've also looked at a number of other powers, not only in Article 1, but last week we looked at Congress's powers under the 14th Amendment. And when you combine those powers with a supremacy clause, you get the supremacy of federal law over state law. We often saw the fights that existed when we're looking at the validity of federal statutes, because we know that if a federal statute is constitutional, then it's supreme to any state law. So there were a lot of fights in the name of states' rights over whether Congress had in fact enacted valid laws, because once the conclusion that the law was valid, it became supreme to any state law. So that is what we've focused on for most of the second half of the semester, is this concept of vertical federalism. But now, in this last chapter, we're turning to a different concept of horizontal federalism. So horizontal federalism describes the relationship between the states, between what we might call co-equal sovereigns. Right? So if the national government is supreme within its sphere, the state governments are never supreme over each other. Instead, they have this co-equal relationship. So how do we make sure that the state governments don't interfere with each other? Right? And that is the basic point of this idea of horizontal federalism, making sure that the states don't interfere with the rights of other states. And this is dealt with in some specific clauses, like the Privileges and Immunities Clause that we're going to be looking at next week, which explicitly talks about discrimination against out-of-staters. But this week we're looking at this idea called the Dormant Commerce Clause. And interestingly, this whole doctrine comes from the Commerce Clause in Article 1, Section 8, the very same Commerce Clause that we've already looked at. But we spent several days, an entire week in fact, looking at the operation of the Commerce Clause as a positive power given to Congress. This week we look at the Commerce Clause in a very different light. We look at the Commerce Clause not as a grant of power to Congress, but as a denial of power to the states. Let me let that sink in for a moment. We're looking at the very same clause that we already looked at. Remember, we looked at Gibbons versus Ogden, we looked at Jones and Laughlin, Darby, Wickard, Lopez, Gonzalez versus Raich. All of those fights over what can Congress do in the name of its commerce power. Right? But now we look at the very same clause and ask the question not what can Congress do, but what are the states disabled from doing because Congress has the powers that it has under the commerce power. So this is sometimes called the negative implications of the Commerce Clause, or sometimes just the negative Commerce Clause, because rather than a positive grant of power to Congress, the court has interpreted the Commerce Clause to take power away from the states, to negate what would otherwise be valid state police powers. Okay. So dormant, where does the term dormant come from? It comes from, well, and I'll show you in just a minute, it comes from a Marshall Court era this decision where the idea is that this power is given to Congress, and certainly we know if Congress passes a law under the Commerce Clause, then that law is supreme, any state law notwithstanding. But here the idea is Congress has not acted, so there is no federal statute to be supreme over any state statute. But nevertheless, this idea of the Dormant Commerce Clause, or as the court calls it, the Commerce Clause in its dormant state, it hasn't been awoken yet by any federal legislation. The Commerce Clause, even in the absence of federal legislation, will sometimes prevent or negate a state statute because that state statute interferes with interstate commerce. So, let me highly recommend that if anything I just said is unclear, you stop now, go back and listen to it again, or consult the handout that I've posted on the Twin page. But it's fundamentally important that you understand this setup here before you move any further. So where did this idea come from? Well, it comes from the Marshall Court era. So in fact, you can find the origins in Gibbons versus Ogden, the case that we read asking the question whether Congress had the power to enact the statutes that it did, giving rights to navigate New York waters. And the court said, yes, Congress had that power, and because it had the power, it was going to trump any state law that was contrary to it. And because there was a federal law, the court didn't have to address the question, but the court raised the question, what if there wasn't a federal law to displace state law? Would there be any problems with state laws that interfered with, or just in and of themselves, seemed to regulate commerce? We know Congress has the commerce power. But does the fact that Congress has the commerce power mean that the states do not have commerce power? Such that if the states tried to do something that Congress could do, the states would be interfering with the constitutional right or power of Congress. The court didn't have to answer that because Congress had acted, and therefore, by virtue of the Supremacy Clause, the federal statute trumped the state statute. The Marshall Court returned to this question a couple of years later, in this case called Wilson versus Blackbird Creek Marsh Company, and the court there uses this term for the first time. They refer to the dormant state of the Commerce Clause. And so, the idea of the dormant state of the Commerce Clause is the Commerce Clause, without any congressional legislation, can awaken all by itself and negate a state law. Right. What is it that awakens the Commerce Clause if it's not a piece of federal legislation that Congress passes pursuant to the Commerce Clause? What is it that awakens the Commerce Clause? Well, it's a state law that interferes too much with interstate commerce. But the court in 1829 said that the Dormant Commerce Clause, or the Commerce Clause, is not awoken from its dormant state by the exercises of legitimate police powers that the states possess. Right. So long as the state is exercising its legitimate police powers, the court said it's not going to interfere with the Dormant Commerce Clause. And about a decade later, Chief Justice Marshall is no longer on the court. This is a court known as the Taney Court, largely influenced by the more democratic stance of Andrew Jackson, who had appointed a number of justices to the court. The court here very much in favor of states' rights, returning power to the people away from the federal government. This court now suggests that anytime you have a valid exercise of state legislation via the state's police powers, they could never interfere with the Dormant Commerce Clause. Justice Story, who was still on the court from the Marshall Court era, dissented, and Justice Story suggested that what the majority said there wasn't true, that sometimes what might otherwise be legitimate exercises of states' police powers, remember the state police powers are the powers to legislate for the health, safety, and welfare of the state citizenry. Justice Story suggested that sometimes those laws might, although be valid exercises of those police powers, nevertheless interfere too much with interstate commerce. And that is the position that the later courts have adopted. We get a functionalist approach suggested still during this democratic court era in the mid-19th century for determining the validity of state laws, where we stay away from a formalist approach that would categorize a law as police power, valid police power, invalid police power, and therefore determine Dormant Commerce Clause does or doesn't apply. Instead, the court said it was going to ask about the practical effects of the statutes. So when the courts engage in functionalist tests, asking about the practical effects, the tests are going to be very ad hoc. They're going to be balancing the pluses and minuses of the legislation against the pluses and minuses of the constitutional right that's to be protected. All right, so why would the court do this? The terms of the Commerce Clause don't seem to have anything to say about state statutes. Remember, the Commerce Clause simply says the Congress shall have the power to regulate commerce among the several states. Right. Why pull from that positive grant of power to Congress this negative implication that works to invalidate state statutes? A few reasons are traditionally given for this power of the Commerce Clause, this negative power of the Commerce Clause. One is a free trade theory, that the constitutional framers designed the national government to essentially be a single market. Right? You don't want states, in fact, states are prohibited from imposing duties on each other, and you don't want states to do anything that's the functional equivalent of that. Right? You don't want it to be unfavorable to do business in one state versus another. You don't want the states discriminating against each other's goods or products. Right? So a free market theory. Another rationale is to protect national unity, which flows closely from that last rationale. Right? If the states are making it difficult for each other to do business within their own boundaries, then this could lead to wars against, trade wars against the state. This could lead to bad feelings, would undermine the concept of national unity. Another justification, this one is somewhat different from the previous two, has to do with the political process. So the idea here is if a state interferes too much with interstate commerce by passing its own state laws, and the interference is such that it's more difficult for out-of-staters to do business within the state, then the state laws themselves are not going to be subject to any sort of voter ratification by those individuals who are harmed most by the legislation. Right? So a discriminatory law, a law that discriminates against interstate commerce, a law that interferes with interstate commerce, at its worst, at its at its most discriminatory, would only harm those who live outside of the state. But those who live outside of the state don't vote for state legislators, they don't vote on state referenda. Therefore, the people most harmed by state laws that interfere with interstate commerce are those that never have a vote or never have a say over the state law. Right? And so that's an argument from the political process that state laws that have a sort of extraterritorial effect are problematic because those outside of the state's territories never have any say in the state's political process. We'll see that some of these same theories will be used to justify the application of the Privileges and Immunities Clause of Article 4 that we will look at next week. All right, so we have this concept of the Dormant Commerce Clause. It comes from the same Commerce Clause that gives Congress power. It is considered it's one of those odd doctrines because it's textual in the sense that it comes from the Commerce Clause, but it's non-textual in the sense that it is a reading of the Commerce Clause that doesn't derive from the words of the clause itself. So within this clause, within this idea of the Dormant Commerce Clause, the court is going to break up the way that it scrutinizes state statutes under this theory into two different sorts of review. This is going to be the first time that we are introduced to heightened or strict scrutiny and be expected to apply it. So we learned about heightened scrutiny or strict scrutiny last week when we were looking at Section 5 of the 14th Amendment, and we saw there the court say that how much evidence Congress had to provide to show that it was actually remedying state violations depended on the level of scrutiny that discrimination against certain groups received. This week, we're going to be introduced to this concept and be expected to apply this idea of heightened or strict scrutiny. Now here, with the Dormant Commerce Clause, the court will give us only 2 levels of scrutiny, not 3 like I explained to you last week the Equal Protection Clause has. So here, the Dormant Commerce Clause will introduce us to 2 levels of scrutiny. And the first level of scrutiny, I think a better title for this slide would just be levels of scrutiny, because I want to explain both levels of scrutiny, rational basis and then heightened scrutiny. So rational basis, the court will apply to laws that do not discriminate against interstate commerce, state laws that do not discriminate against interstate commerce. And the court will simply ask, does the legislature have a good reason for passing the statute? What does that mean? Another way to ask it is with this question. Can a reasonable person imagine how the state legislature might have thought the law would fix whatever problem the legislature was confronting? Again, if it's non-discriminatory, the court is not going to inquire into the wisdom of the law. The court isn't going to say, would I have voted for that if I were a state legislator? Nor is the court going to inquire into the actual or likely effectiveness of the law. So if it's a non-discriminatory law receiving rational basis review, the court is not going to say, I don't think that law is actually going to work. That will never be a reason for striking down a law under rational basis review. On the other hand, if the court determines that the state statute does discriminate against interstate commerce, that's when the court is going to apply heightened scrutiny. The court is going to be more suspicious of the state statute. And we're going to come to another section tomorrow where we will be looking at the concept of discrimination. So here I'm just assuming that you'll eventually have a test to determine whether it's a discriminatory law or a non-discriminatory law. We'll start looking at that when we look at the cases. But assuming that you can put the state statute into the discriminatory category, then we apply heightened scrutiny. So if this is the case, if the state statute does discriminate against interstate commerce, then a rational basis is not going to be a good enough reason to uphold the law anymore. At this point, the burden will shift to the state itself. So rational basis review, the burden would be on the challenger claiming that the state statute violated the Dormant Commerce Clause. If the state statute is discriminatory against interstate commerce, the burden will be on the state. And at that point, the state will have to demonstrate the urgency of the law to the meeting of its legitimate needs. So the state will have to now articulate a good reason for the statute, not just a rational basis for the statute. And unlike with rational basis review, the court will suggest alternative ways that the legislature could have accomplished the same objective. The court will say, I understand your reason, state, for passing this statute, but we see a different way that that same goal could have been accomplished that would do less damage to interstate commerce. And if the court can find such an alternative way, the court will usually strike down the state statute because the court will say there's a less restrictive means through which the state could have accomplished its same goal. That is, less restrictive on interstate commerce means for accomplishing the goal. So here's a summary of the Dormant Commerce Clause test. You look at the state statute and you put it into one of two categories. Either the law will regulate even-handedly with only incidental effects on interstate commerce, or the law will discriminate against interstate commerce either on its face or in practical effect. So the law is going to be classified into one of two categories that correspond to those two levels of scrutiny. And if the law is not discriminatory, if it regulates even-handedly, then the law is presumed valid. And the law is only invalidated if the burdens on interstate commerce clearly exceed the putative local benefits. That will be a test that we eventually derive from a case that we'll look at tomorrow. Right. So if it's a non-discriminatory law, it's presumed valid, only invalidated if the burdens on interstate commerce clearly exceed the putative local benefits. If it's a discriminatory law, then the law is presumed invalid, and the next two questions must be asked. Does the statute serve an important local purpose? And remember, the burden will be on the state at this point. The state will have to come up with that important local purpose. And then the court will ask, are there alternative means to promote this local purpose as effectively without discriminating against interstate commerce? All right. So we'll have practice applying this test in the next couple days. The set of cases that we have here, starting on page 339 of the casebook, under the heading, The Evolution of the Modern Rule, there's four main cases here, and two of them are examples of, so all of these are early cases, and so these are cases that the court decided before it came up with its modern two-part test, or its modern bifurcated test between discriminatory and non-discriminatory laws. But we see in these early cases these ideas starting to come up, and we see the early justifications that the court will still use today. So these cases are still good law. They're just not worded in the same in the same uniform tests that the court will eventually adopt. All right, so the first two cases, under the subheading here, heightened scrutiny for discriminatory laws, and then the second two cases will look at non-discriminatory, applying this rational basis or balancing type test that the court comes up with. All right. The first case we have is Baldwin versus GAF Seelig. And this will be an example of a very pragmatic functionalist analysis of the Dormant Commerce Clause. So here we have a New York statute that sets minimum prices that dealers have to pay milk producers. Right. All producers must pay this minimum price, not just New York producers. So, bottom of page 339, the substance of the provision is that there shall be no sale within the state, within New York, of milk bought outside unless the price paid to the producer was one that would be lawful upon a like transaction within the state. Right? So retailers then, people who are going to sell milk to consumers in the state of New York, they purchase their milk from wholesalers, and the idea here is that the prices that they pay must be a certain minimum price that have to be paid to the dealers. So, what is the practical effect of this statute? And why does New York say that it is passing this statute? So let's go to page 340. Second paragraph, New York asserts her power to outlaw milk so introduced by prohibiting its sale thereafter if the price that has been paid for it to the farmers of Vermont is less than would be owing in like circumstances to farmers in New York. So if Vermont farmers are selling their milk at a price that's cheaper than what New York dairy farmers are selling their milk for, essentially the retailers in in New York would have to say to the Vermonters, look, we know you're only asking 10 cents per bottle, but in New York, the New York farmers are selling it for 15 cents, so therefore, Vermont farmers, we have to pay you the 15 cents, even though you're not asking for it. Now, is that what is actually going to happen? Likely not. Instead, what's going to happen is that people are just going to buy milk from in-state farmers, and perhaps that's the point of the statute. Right? What does the court say about this statute? The court says it has the effect of a duty on imports from out of state. So next, third paragraph, such a power, if exerted, will set a barrier to traffic between one state and another as effective as if customs duties equal to the price differential had been laid upon the thing transported. Right? So in my example, if Vermont is selling their milk at 10 cents a bottle and or whatever the equivalent of the volume would be. And in New York, it's 15 cents. The court here is saying the practical effect is that Vermont dairy farmers would be charged a duty of 5 cents per bottle for all milk coming into New York. Right? And therefore, the court says, so my question is, why heighten scrutiny? The answer, according to the court, is that this law is discriminatory. Right? The court says its necessary tendency is to suppress or mitigate the consequence of competition between the states. And if this is allowed, the court says in that same paragraph, then the door has been opened to rivalries and reprisals. Right? If Vermont feels that its farmers are being discriminated against in New York, Vermont might somehow engage in some sort of economic war with New York. Now, what's the justification? So we get the justification in the fourth paragraph on page 340. The argument pressed upon us, according to the court, is that the New York statute is something more than mere economic warfare. The end to be served is the maintenance of a regular and adequate supply of pure and wholesome milk, the supply being put in jeopardy when the farmers of the state are unable to earn a living income. Price security, we are told, is only a special form of sanitary security. So remember, the police powers of the states are the powers of the states to legislate for the health, welfare, and morals of their citizenry. So what New York is claiming here is that this is essentially a health measure, a sanitary measure, that New York dairy farmers have to be able to make a living, right? That's important not only for the farmer's own well-being, but for the well-being of the farm itself. If New York farmers are struggling, then they're going to cut corners at their farm. And what might take a hit is the sanitary condition of the farm, right? And therefore, that is going to impact the public health because the public might then be getting milk from New York farms that have less than sanitary conditions, all because the farmers are having to cut corners because they're not making as much in profit as they once used to. So the state says this is a sanitary health measure. Right? The court says, though, that so why is this justification insufficient? The court says to give entrance to that excuse would be to invite a speedy end to our national solidarity. National solidarity is the answer the court gives as to why that's not an acceptable excuse for the New York statute. Notice that this is 1935, so the height of the Great Depression, right? Roosevelt has only been elected a few years before, and Roosevelt doesn't really, you don't see real results until Roosevelt's second term. So here, people are still struggling. New York dairy farmers are clearly struggling, and New York is trying to find a way to help them. But notice what the court does in this case. The court essentially says that, so the court doesn't deny that New York farmers might need help, but the answer, the court says, is not putting the state itself into a position of economic isolation, the last paragraph on page 341. Economic isolation, economic barriers are not the solution. What is the solution? Well, the court says the solution is going to have to be a national solution. Right? It says the Constitution, bottom of page 340, was framed under the dominion of a political philosophy less parochial in range. It was framed upon the theory that the people of the several states must sink or swim together, and that in the long run, prosperity and salvation are in union, not in division. So this opinion was written by Justice Cardozo, one of the individuals that generally tended to vote for President Roosevelt's New Deal programs. So you can see, I think, if you look at it from that perspective, what's going on here. The court is trying to say that New York's rationale is not really a rationale that can be solved at the state level with state legislation. Right? If the idea here is that economic prosperity is in danger, then it's only to a national solution that the states can look. Right? So here, the court strikes down this legislation. It interferes too much with interstate commerce. It's discriminatory against out-of-staters. In particular, you can see that discrimination against Vermont here. And the justification doesn't work when you have a statute that is practically discriminatory. All right, the next case also deals with milk. This is the Dean Milk case. Here we have an ordinance from the city of Madison. Why is this ordinance going to be evaluated under heightened scrutiny? Well, the court tells us that the law has a discriminatory effect on interstate commerce. So what did the ordinance do? The ordinance required that milk be processed, that any milk sold within the city limits be processed within 5 miles of the city. The pasteurization process had to take place within 5 miles of the city, and that suppliers of the milk, the farms, had to be within 25 miles of the city. And here we have some Illinois farms, some Illinois pasteurization plants that are 65 and 85 miles away from Madison, and they were denied a license, and so they are suing. The court says, middle of page 342, we agree with the appellants that the ordinance imposes an undue burden on interstate commerce. So what is the justification for this city ordinance? Well, you can see page 342. The justification given is the safety, health, and well-being of local communities. So again, a police powers type of justification, and the court doesn't deny that cities can pass regulations in the name of safety, health, and well-being of their local communities. So what's the problem? Well, the problem, as the court says in the last paragraph on page 342, is that this regulation, like the provision invalidated in the Baldwin case, in practical effect excludes from distribution in Madison wholesome milk produced and pasteurized in Illinois. Instead, the states must take a non-discriminatory path towards its legitimate end. So safety and health are perfectly fine ends for a state to pursue, but they must pursue those ends in non-interstate commerce discriminatory ways. So the court says, even in the exercise of its unquestioned power to protect the health and safety of its people, if reasonable, non-discriminatory alternatives adequate to conserve legitimate local interests are available, then essentially it must use those alternatives. So what are the alternatives then? What were the less restrictive alternatives that Madison could have pursued? And what was the health rationale given here? The health rationale given here is that the state inspectors, the city inspectors, in order to guarantee healthy milk being sold in the city of Madison, need to be able to inspect these plants and these production farms. And the city inspectors can't travel that far in order to do their job. They shouldn't have to be traveling out of state just to make sure that these places pass inspection. But what does the court say about the alternatives? It appears that reasonable and adequate alternatives are available, and the court then comes up with some ideas of its own. They say that the city could inspect the foreign milk and pass the costs on to local importers. So if the city doesn't want to have to bear the cost of traveling to go and look at faraway farms, the farms, if they wanted to sell milk in Madison, then they might have to pay for the city inspector to come out. The court suggests that that would be better. That would be certainly less discriminatory than the statutes now. Or another alternative would be for the city to rely on federal standards in exporting the milk, or in importing the milk from these other places. There could be some sort of there's a model milk ordinance that's been recommended by the United States Public Health Service, and this could serve as the safety mechanisms in a non-discriminatory way. So at the bottom of the conclusion here is that to permit Madison to adopt regulations not essential for the protection of local health interests and placing a discriminatory burden on interstate commerce would invite multiplication of preferential trade areas destructive of the very purpose of the Commerce Clause. So note, the court finds this is a statute that is not essential to achieving the legitimate state interests of protecting the public health by selling milk that's been inspected. So again, you only see that second guessing. You only see the court questioning and suggesting alternatives when the court is engaging in some sort of heightened scrutiny. And here we have a dissenting opinion written by Justice Black, and note that Justice Black is critical of this heightened scrutiny. On page 344, he talks in the second and third paragraph about the court's proposals, right? These alternatives that the court is suggesting. And for Justice Black, that sounds too much like the court is engaging in policy revision or in legislation rather than in judging. And Justice Black is also critical of the non-textual nature of this Dormant Commerce Clause idea, right? Explaining that, or questioning where the court gets the constitutional basis to put this idea of free trade above local safety concerns. All right, so that's how the court started to deal with laws that it found to be discriminatory. How did the court deal with laws that didn't turn out to be discriminatory? Laws that seemed to apply their regulations equally. Right? So the discriminatory nature of the New York law was that only out-of-staters were burdened by the minimum price law. The argument in the Wisconsin case is with those geographical limitations, only out-of-staters, although it's not true that only out-of-staters, but certainly out-of-staters more than others would be burdened by those geographical limitations. So practically speaking, it was discriminatory. So what about laws that don't discriminate in that fashion, but instead apply equally to both in-staters and out-of-staters? That's what will be characteristic of a non-discriminatory law. So let's look at this first case, South Carolina versus Barnwell Brothers. So here we have state laws that regulate the weight and the size of semi-trailers. Why is the restriction non-discriminatory? See, it says so the state statute says that semi-trailer motor trucks whose width exceeds 90 inches and whose weight including load exceeds 20,000 pounds are prohibited. The principal question is whether these prohibitions impose an unconstitutional burden on interstate commerce. So first, the court notes that highway laws are usually reserved to the states. Now, I will note that this is a 1938 case, and this is a case that was decided before the Interstate Highway Act was passed in the 50s under President Eisenhower. But here, we're reading the case to see how the court goes about applying this balancing test for non-discriminatory laws. So one thing the court points out is that in order for road laws, in order for highway or traffic laws to be effective, they must apply uniformly. So there can be no special rules that apply only to out-of-state cars on the road. Otherwise, that would undermine the effectiveness of any sort of road law. Now, the court says on page 346 that a statute may not, under the guise of regulation, discriminate against interstate commerce. Then the next paragraph, the court says, but so long as the state action does not discriminate, the burden is one the Constitution permits, because it is an inseparable incident of the exercise of legislative authority, which under the Constitution has been left to the states. So here, the court finds that everyone, in-staters and out-of-staters, must comply with these weight limits on trucks. The court says on the bottom of the page that we here apply let's read the test that the court sets out. Very last sentence of the last full paragraph there. The inquiry, the court's function stops with the inquiry whether the state legislature in adopting regulations such as the present has acted within its province and whether the means of regulation chosen are reasonably adapted to the sought end. So they're looking at the reasonableness of the regulation. Here, the first inquiry has already been resolved, and that is, the state has the power to regulate the safety on its own highways. And therefore, second, the courts do not sit as legislatures, either state or national. So note that unlike the previous Milk case that we just read, where the court is going to start suggesting alternatives, here the court is not going to inquire into the wisdom of the policy or the effectiveness of the policy, because it's determined that it is a valid police powers regulation, and it is a police powers regulation that is non-discriminatory, applies equally to in-staters and out-of-staters. So note the justification for this more lenient test for state laws that are non-discriminatory, bottom of page 346. When the action of a legislature is within the scope of its power, fairly debatable questions as to its reasonableness, wisdom, and propriety are not for the determination of courts, but for the legislative body, on which rests the duty and responsibility of decision. This is equally the case when the legislative power is one which may legitimately place an incidental burden on interstate commerce. It is not any the less a legislative power committed to the states because it affects interstate commerce, and courts are not any the more entitled, because interstate commerce is affected, to substitute their own for the legislative judgment. So the point here is, yes, this might have some effect on interstate commerce, some incidental effect, but because the point of the statute is not to discriminate, and it doesn't discriminate on its face, then the statute will be upheld unless it can be shown that there's an excessive burden on commerce. And here, that hasn't been shown. Okay, so next case, Southern Pacific versus Arizona. So here we have a state statute from Arizona that limits the length of trains that pass through the state, makes it unlawful to operate within the state a railroad train of more than 14 passenger or 70 freight cars. Now this statute, like the South Carolina highway statute, applies to everyone, not just out-of-staters. So Arizona-based trains and out-of-state-based trains must comply with this length limitation statute. The court says at the bottom of page 347, so that's why it's non-discriminatory. It applies to everyone. The court says at the bottom of the page, the matters for ultimate determination here are the nature and extent of the burden which the state regulation of interstate trains adopted as a safety measure. So the justification here is that it's a safety measure. Long trains might flip over more quickly than shorter trains. Whether these burdens are excessive relative to the weights of the states and the national interests involved, relative to the state. So, does it too much burden the free flow of interstate commerce? So, what do we know here? What sorts of questions do we have to ask? Top of page 348. The court, first of all, describes the situation nationwide involving the size of trains. And it says that long trains are actually the nationwide norm. Moreover, the court says that there is a need for national uniformity in train lengths regulations. The court says, national uniformity in the regulation adopted, such as only Congress can prescribe, is practically indispensable to the operation of an efficient and economical national railway system. So note here, the court is talking about a national railway system. The railways, the trains were regulated nationally by Congress since the Interstate Commerce Commission was created in the late 19th century. As I mentioned in the previous case, the national highway system had not yet been developed in that case. That might explain one of the difference to the approaches here. But the court finds that, next paragraph on page 348, in Arizona, approximately 93% of the freight traffic and 95% of the traffic, passenger traffic, is interstate. So in other words, the vast majority of trains coming through Arizona are coming from out of state. Very few originate in-state. And therefore, the court concludes, the unchallenged findings leave no doubt that the Arizona train limit law imposes a serious burden on the interstate commerce conducted by the appellants. And the court notes that, practically speaking, there would be chaos if every state had different laws. So the court says, imagine if every state did this, if every state had different train length laws. What happens practically here is that the trains must stop at the borders right before they enter Arizona. They must stop at the California border and at the New Mexico border, at the Texas border, in order to change change train sizes, right? So the Arizona law is putting a real hitch in the free flow of interstate railway commerce here. So the court calls the burden serious. Right? And because the burden is serious, the court is going to essentially apply a form of heightened scrutiny here. The court has now found at this point that the burdens seem to outweigh the benefits here. Okay. So if we look on page 349, the court says that we don't ask a simple rational basis inquiry. In considering the effect of the statute as a safety measure, therefore, the factor of controlling significance for present purposes is not whether there is a basis for the conclusion of the state that the increase in the length of trains beyond the statutory maximum has an adverse effect upon safety. Instead, the decisive question is whether, in the circumstances, the total effect of the law as a safety measure in reducing accidents and casualties is so slight or problematical as not to outweigh the national interest in keeping interstate commerce free from interferences which seriously impede it and subject it to local regulation, which does not have a uniform effect on the interstate train journey which it interrupts. Right. So here, the trial court had actually, so this was heard in state court. The state trial court had actually found that this statute did not pose very many benefits to the state of Arizona and was more burdensome on interstate commerce. The Arizona Supreme Court had reversed and found that there was a safety reason attached to this statute. But note what the court is saying in that paragraph that I just quoted is that the question, because the burden is so serious here, the burden on interstate commerce, The question is no longer, does the state have a legitimate justification? Instead, the question is, are the safety burdens so great, or are the safety benefits so great that they outweigh the serious burdens on interstate commerce? And the court finds that the answer to that question is no. Right? Instead, the court judges the state law benefits for itself. Bottom of page 349, we think as the trial court found, and then they explain why this statute doesn't really bring any benefits to the state. And Justice Black dissents again, just like he did in the Dean Milk case. He accuses the court in its heightened scrutiny analysis, in its weighing the benefits and burdens for itself, accuses the court of acting as a super legislature. He finds that there is no legal standard for determining train length safety. In other words, he is saying, how can the court decide that there isn't a sufficient benefit to the state here? That seems more like a policy judgment. And then there's one other note case that's worth looking at here on page 351. This is Bibb versus Navajo Freight Lines. Here, this case deals with an Illinois statute requiring the use of contour rear fender mud guards on trucks and trailers operated in Illinois. So Illinois thought that the contoured mud flap would be safer for trucks and trailers to use on Illinois roadways, but apparently the national standard was the straight mud flap permitted in 45 states and required by another state law, Arkansas law. So this is a non-discriminatory law because it applies to everyone. Illinois trucks have to use them as well as all out-of-state trucks. So it seems to be non-discriminatory on its face. But the court finds that this statute looks more like the Arizona law than the South Carolina law, in the sense that this law poses a excessive burden on interstate commerce. So as the court says on page 352, this is one of those cases, few in number, where local safety measures that are non-discriminatory place an unconstitutional burden on commerce. Because Illinois is such an outlier, just like Arizona was an outlier with train size, Illinois is an outlier with this type of mud flap, that essentially either everyone would have to change to this mud flap, so Illinois would be setting the national standard, or all of these trucks would have to stop at the border and change their mud flaps, thus causing a major burden to interstate commerce. All right, I'm going to end it there. The reading for next class is on the Twin site. There's a series of Dormant Commerce Clause cases that are there. Some of them have my notes on them. Hopefully that will help you get through them. The reading for Tuesday are cases that are much more modern, more recent. So please let me know if you have any questions, and I'll talk to you tomorrow.